Well, hello, and welcome back to another exciting edition of Coffee with Stephen. So, this week's blog is somewhat of an interesting one. We had a court case come down last week in Massachusetts. It was actually a non-decision decision. Essentially, the judge said that he doesn't feel that he has jurisdiction to rule in this particular matter, but he went ahead and essentially issued a ruling anyways, espousing on his own belief system. This had to do with Massachusetts assault weapons, and I use the term obviously in quotes, prohibition. You guys might remember that for 10 years there was a federal assault weapons ban. About halfway through that ban time, Massachusetts enacted their own version of the federal assault weapons ban. In any event, they were sued and it's been going through the courts, and we finally got the beginnings of a ruling. I won't go into all the dicta of that particular ruling, but there is one thing that I found particularly troubling. In the ruling, he essentially says that the Second Amendment does not apply to weapons like AR-15s. Now, that's fine. He can come up with any sort of rationale he wants, except for a complete abrogation of the prejudicial history. He used Heller. And you guys might remember, Heller was the Supreme Court decision where Justice Scalia articulated that not only was there a fundamental right to keep and bear arms, but that right was not a collective right, that it was an individual right. In any event, he uses Heller as the basis for his argument that AR-15s and the variants of AR-15s are not covered by the Second Amendment. Specifically, he states that in the Heller decision, Justice Scalia articulated that a weapon that has a military use is not covered by the Second Amendment. Now, that would be a troubling statement. Fortunately for us, it's completely fabricated. Nowhere in the Heller decision does it say this. In fact, it says the exact opposite. It says in his discussion with what Justice Stevens was arguing against the Second Amendment, he said that weapons with a military purpose are specifically covered by the Second Amendment. That was the whole point. So it's kind of like if I make up a law that I don't particularly like, other people can try to reinterpret that law, but the reality is they could just go ahead and completely ignore it or make up their own version completely. This is probably one of the most troubling aspects of modern jurisprudence. If you don't like what your opponent says, fabricate a statement, come up with something completely different, and then argue against that. So in any event, I encourage you to read the blog. It'll probably make you as infuriated as it made me writing it. But in any event, as I always say, if you have any questions, any comments, or you'd like greater information, feel free to contact me at stephen@artemishq.com. And above all else, train constantly, train consistently, train with purpose, and stay vigilant out there. Thank you until next week.